Now, I still think there's a few people who will be joining, so I'm hesitant to start just yet.
Kick it off. Yeah, no problem.
I'll wait a couple of minutes and then I guess I'll hand it over to you. Maybe for the people who have joined, I'll give a quick introduction in case they were wondering who I was. Probably not. But my name is Jotaro. I work as I'm a business development officer is my title. I work as part of the business development team at MAG and have done so for about a year and a half now. So today, unfortunately, Mark Gibbons, who is our managing director, he is unable to attend and he normally hosts these meetings. So you're stuck with me instead, for better or for worse. And so I'm just gonna admit got another person coming in. And yeah, so I'll be hosting today. If you had any, I guess, questions or queries and stuff like that, I was going to say, Danielle, with questions, would you prefer that people were asking questions during the seminar, or if it was sort of they were waiting till after the seminar, after the end of your presentation to ask them, or what's your preference there?
Probably, well, I've allocated some time at the end for questions, hopefully. Probably the end will be easier. If people are putting questions in the comment box, because I've got two screens, I can't often see the questions as they come through. So probably easier to deal with them at the end.
Yeah, and I guess people can do oftentimes, you might, for the people who are participating, they might have a question they realize 30 minutes after the presentation is actually finished. And
yep.
I'll be sending out probably a follow-up email to everyone after the seminar. And with that email, I usually would provide, with your permission, of course, a copy of the presentation and a recording of the presentation for their reference. And you're welcome to also send me an email, reply to me with any questions that you wanted me to follow up with, and I can probably ask Danielle, who might be able to answer those. So yeah, I guess the other thing I would say is, I think everyone's probably pretty well versed in Zoom meetings and stuff now, but I guess just make sure your microphones are muted. I can mute them for you if you have trouble with that. But I feel like it should be fine. To give you a really brief introduction on Danielle. So Danielle is the principal of Little Estate Lawyers, which is a nationally accredited mediator, and the owner of Little Legal Mediation. So Danielle, I guess quickly before we presented, wanted to thank you on behalf of MAG and everyone participating for, I guess, your continuing education of this sector and what I'm sure will be a really entertaining presentation. So I'll hand over to you, and if you'd like, you can share your screen with the presentation.
Thank you.
And if not, let me know. And I'll probably pop myself on mute and turn my camera off, and then I'll be here with any questions if you had any. Okay, cool. I think everyone should be able to see that. Great, I can see that. I think everyone else should be able to see the same thing.
Okay.
And over to you. Thanks, Danielle.
Excellent, thank you. Thank you for the introduction. So I am a wills and estates lawyer. I specialise in all things estate related. I put together this presentation today. It's called Catastrophic Injuries in Estate Planning. It's really difficult to make death sound exciting, but I thought moving beyond catastrophic injuries, we sort of move into the death area a little bit as well towards the end of the presentation. It kind of gives a bit of an overview of a scenario that is a fairly regular scenario that comes across my desk, and it is sort of based around a couple of my current matters that have very similar circumstances at this point in time. So I thought I'd go through a bit of a scenario to give a bit better of an explanation and understanding in relation to the workings of estate planning and the importance of it, given that I deal with a lot of injury related clients. I thought it was a good scenario to use for injury lawyers who will hopefully get a bit out of the scenario. All right, so this scenario is a husband and wife, John and Rebecca, and they are involved in a motor vehicle accident. John suffers a severe neck injury and he dies at the scene. Rebecca is unconscious at the time. She's still breathing, but she's in a pretty bad way and she's taken to hospital. So Rebecca has suffered a range of injuries. She's got some quite serious injuries to her neck, her back, her hip, her leg, and also suffered a head injury. She was in hospital for 4 months. Her husband, John, his funeral was delayed by several months because Rebecca was too unwell to leave the hospital and attend, both physically and mentally, in quite a bad way. So some of the problems that arise for Rebecca, for her personal scenario with no estate planning in place, and by estate planning, I'm talking about just the basics here. I'm talking about a will and an enduring power of attorney. So she has no will and she has no power of attorney. And there's a problem here with her capacity. So she's taken unconscious after the accident to the hospital. It's unknown when she'll wake up, and if she does wake up, what her capacity is going to be like to make any decisions and manage any of her affairs. Rebecca doesn't have any family close by. Neither of her parents are alive. She does have 2 siblings, but they live in another state, and she hasn't had anything to do with them for almost 10 years. They've had a pretty poor relationship. And doesn't really acknowledge them as siblings at all. So given Rebecca's circumstance, there needs to be some decisions made for her. So she needs some personal and health related decisions made in relation to current treatment, any emergency surgery and things like that. She also needs some financial decisions made. So in relation to personal and health related decisions, in a scenario like this, who can actually make decisions for Rebecca? In this case, it's her next of kin, which is her siblings that she has absolutely nothing to do with, and she would not like them having anything to do with any of the decisions made in relation to personal and health related matters. For her, it would just be a disastrous thing to occur. Financial related decisions, there also needs to be some things looked after. So being in hospital for 4 months, there are a lot of things that don't occur. Things like bills don't get paid, and what happens when you don't pay bills. Services get cut off, you don't pay your electricity bill, you don't pay your internet. Those types of things can be cut off. If you've got direct debits and they're coming off cards, you can get charged fees for your bank being drained or funds being drained, and you have no, and you're overdrawing on accounts. She's also suddenly not able to turn up to her work, so someone needs to be able to speak to her employer. What happens in this circumstance? Does she take leave? What is the scenario with her employment? Someone also needs to speak to banks and start trying to put some action in place in relation to mortgages that need to be paid and things like that. So when someone is in a situation like this, sometimes banks have financial hardship provisions that they can do all sorts of things in relation to suspending payments or reducing payments on loans and things like that, because obviously when you're out of work for a few months, you're not necessarily getting paid. She might also have some sort of insurance in place that needs to be actioned so that she's got some money coming in so that she can attend to her finances, or someone can attend to her finances, and she can have all of the funds available that she needs for medical treatment, etc. So at the moment in her current scenario, there's nobody that can actually do anything around these sorts of things because there's nobody authorised at this point in time. So that makes life very difficult for her. So what can actually be done to help Rebecca in this particular scenario? I've based this on Queensland, but a similar process for most states. So an application can be made for someone to be her guardian administrator through Queensland Civil and Administrative Tribunal. But who can apply in these types of circumstances? Well, there's a number of people that can apply. It can be anyone that is over 18 years of age, anyone that respects the decision-making principles that are set out in the relevant legislation, anyone that has that doesn't have a conflict of interest in making decisions for her. It can be anyone that is going to be compatible with making the right decisions for her, and anyone that's actually willing to act in accordance with all of the rules and regulations for being an administrator and a guardian. So in this particular circumstance, what you would often see is family actually applying. So she doesn't really have anyone else around her that can apply to be her guardian administrator. So her siblings can apply. And again, she would be mortified if that actually occurred. So how long does it actually take for a process to go through a tribunal like this? Or how long is a piece of string, essentially? So when it comes to making applications through a tribunal like this, you can make urgent applications. What's urgent to the tribunal in their view might be different to what's urgent in your view. To give you an example of one that I assisted a client with towards the end of last year, involved his father and his stepmother, who were very elderly, living in a Queenslander. Stairs up to the house, the father was in a wheelchair, the stepmother had severe dementia, and the father's cognitive abilities were also on the decline. So he was starting to suffer early signs of dementia and starting to get a little bit of paranoia and things. The household that they were living in, because the stepmom had such severe dementia, she would forget that she's purchased food and she would constantly buy food. Fridges and cupboards would be overloaded with food. She didn't know what day or date it was, so she was cooking food that was far out of date, and the house was a mess. It had a stench in it because of the keeping of food that was so off and cooking of food that was so off created quite a bad stench in the house, and they were also hoarding things as well. She also didn't like to throw anything out. So the living environment was pretty terrible. The father couldn't actually get around in his wheelchair. He couldn't get into the bathroom to bathe himself. The demented wife wouldn't allow any modifications to the home because she didn't understand that he couldn't get into places like the bathroom. So there was an issue with their personal hygiene. They weren't attending to medical appointments. They were living in filth, and there was a real fear of them, one or both of them, having a very severe fall that would essentially kill them. So even when you have a circumstance like that, an urgent application was made in that circumstance to QCAT. It took 3 months just to get an urgent order for a guardian to be in place for personal and health related decisions to be made in this circumstance. And then it took a further 4 months for a financial administrator to be appointed. So in that circumstance where people's lives are in quite a bit of danger and they're quite elderly, and it takes that long just to get something urgent done, in a case like this, QCAT may not think that someone laying in a hospital bed that's being looked after is a particularly urgent case. So who knows how long it would take to actually get anyone appointed to start making decisions for her and attending, in particular, to financial matters. So it's not an ideal scenario to be in. But what happens if Rebecca actually dies? So she's really sick and say she's in a coma in hospital. What happens if she actually dies? Unfortunately, because she doesn't have a will in place, then intestacy laws apply for her. So who does her estate actually go to? Her delightful siblings that she certainly would not want to be getting anything of hers. So in this case, let's say that Rebecca has 3 stepchildren who she has a really good relationship with. Let's say that she does have a good relationship with her siblings. And let's assume that she has told people what it is that she wants done with her estate when she passes away. So let's say that she's still alive, she's still in a coma, but she's actually alive, and there needs to be some sort of action taken for her to have a will in place. In this particular circumstance, with her in a coma and not having capacity to make a will, and obviously no one else can do that on her behalf, even if she does have a guardian and administrator in place, the only person that can make a will in this circumstance is the court. So someone could apply for a statutory will. Now, applying to the court for a statutory will is not a straightforward thing to do. There's essentially a 2-stage process involved in getting a statutory will. So the first stage is really just applying for leave to make the application. And there's a range of information that the court requires in this circumstance. So the information that is provided is a statement as to why the person can't make a will themselves. There needs to be evidence regarding the lack of capacity, which in this circumstance is pretty easy. She's in a coma. It's just a doctor's report. There needs to be some sort of information in relation to the size and the nature of her estate as well. Is there property? Is there bank accounts? What is there that needs to be distributed in this will? A draft proposed will needs to be provided to the court as well. And any evidence of Rebecca's testamentary wishes. So if she's spoken to people about what her wishes are, then it would be affidavit evidence of those people. If she's written anything down in notebooks, if she's saved anything on a computer, all of that kind of thing would be evidence that needs to go to the court. And any evidence regarding any potential family provision applications. So in this case, we're assuming that she has 3 stepchildren, so there's room for family provision applications in Queensland at least. In New South Wales, it's a little bit more difficult for stepchildren to make a claim against an estate, but certainly from Queensland perspective, they're eligible people. The second stage is the main stage of the application, and what you often see in statutory will applications is they're essentially heard on the same day. The judge might hear the application for leave in the morning, and if leave is granted, then they might say go away and come back in the afternoon and let's start the rest of the application. But essentially, the requirements that need to be met, and again, this is from a Queensland perspective, the person needs to lack testamentary capacity. The person needs to actually be alive. And the court also needs to approve the proposed will. So when we're talking about approving the proposed will, there's actually, there needs to be an order made to make the will, which needs to, and the will itself needs to be in writing, but the will itself also needs to be signed by the registrar. So in these types of applications where they're particularly urgent and they might be after hours or they might be a weekend application, not only does there need to be a judge available to hear the application, but there also needs to be a registrar available to sign the will. So if the court sees the draft, the written will, and is happy to make the order that that be this person's will, if between the time the court makes that order and the registrar signing the will, if the client dies, then there's no will in place. So that's why it's really important for these types of applications. You've got to have everybody there on the day available. So the minute that judge says, yep, this is the person's will, and I'm making that order, the registrar is sitting there and signing the will. So after going through that little bit of a scenario, the importance of having estate planning in place, obviously you never know when you're going to be involved in an accident. We don't have a crystal ball. None of us know. It could be today, it could be tomorrow, it may never happen. But we just never know when we're going to be in some sort of an accident. And these types of scenarios are the reason why I always say to people, it doesn't matter how much you have or how little you have, you always need to have just the basics in place. You need to have a will and you need to have an enduring power of attorney, because in that circumstance, you're not relying on the law or some registrar at a tribunal to appoint someone to make decisions for you. You're actually making them yourself. So what we don't want to see, particularly in cases where people are left behind, where someone doesn't have estate planning in place, is we don't want them walking into our office and making this face. We never want to see this face. We always want to see this face. So having just the basics done and making sure that people are in charge of their own decision making and they've got the right people in place, particularly with enduring power of attorney documents. And for New South Wales people, enduring guardian and enduring power of attorney documents is really, really important. You don't want to leave it to chance that the right person's going to be appointed. It may not be. It may be siblings that you've had nothing to do with for 10 years. So now I thought I'd kind of move forward a little bit and move to what actually happens in this scenario when John dies. So we're going to go to the happy topic of death. Sadly, this is my favourite topic, but I do a lot of estate administration, and there are some pretty tricky things that can come up and some pretty unfortunate things as well that can arise when someone doesn't have their estate planning in place. So this is John's estate. We're administering his estate. And I mentioned before Rebecca had 3 stepchildren, and that's because John has 3 children. So he's got 3 children to a previous spouse. He has a house that he owned in his own name, and it has a mortgage over it. He also has a house that he owns with Rebecca, and they own that as joint tenants. It also has a mortgage over it. He has superannuation, but he doesn't have a binding death benefit nomination in place. And for those that don't know what a binding death benefit nomination is, I actually get to that a bit later in the presentation when I explain a bit about the difference between administering an estate when there is estate planning in place and when there's not estate planning in place. He also has a business. He had a loan to buy some equipment that he needed for his business, like trucks and things, and he signed a personal guarantee to secure the loan. So for those who are unfamiliar with what a personal guarantee is, you're basically in a lot of cases putting every asset that you own, whether it's owned solely or jointly, up for grabs for a creditor if you can't afford to pay your loan. And no will in his circumstance means that the intestacy laws apply. Now, intestacy laws can be a little bit like putting a jigsaw puzzle together. They're not always favourable. They're not always what the deceased may have wanted, but when they don't have a will done, then too bad, so sad, we get stuck with these intestacy laws. So in Queensland, a lot of people assume that an estate automatically goes to a surviving spouse, whatever the scenario is, whether it's a blended family scenario or not, or a second spouse or not. In Queensland, an estate doesn't automatically go to a surviving spouse. It gets split between spouse and children. In New South Wales, it's a little bit different. In a blended scenario, blended family scenario, it's similar to Queensland, but in a non-blended family scenario, it's completely different. In New South Wales, there is, in this particular scenario with a blended family, they have a really weird formula that gets applied to how much the spouse actually gets. They get the first $350,000 of an estate plus some additional money that's worked out on a calculation, and then the residue gets divided. In Queensland, it's a little bit more straightforward in that there's no weird formula to apply. In this scenario, the surviving spouse would get the first $150,000 of the estate, and then the residue would be essentially divided, with 1/3 going to the surviving spouse and then 2/3 being shared by the children equally. Now, that may not be what John actually wanted to happen, but he stuck with that because he didn't actually have anything in place to say otherwise. So I'll go through and we'll have a look at the assets and liabilities in this particular estate. So we have got, we've got a house. So I'll go through the assets first. We've got the house that they own together. There's a house that's essentially the investment property. There's bank accounts that he has jointly. He's got some bank accounts in his own name. He's got company assets and he's got company bank accounts, and he's also got some superannuation, but he doesn't have a binding death benefit nomination in place. And the liabilities, both of the houses have mortgages over them. He doesn't have a huge amount of equity in his properties. He's got a credit card debt, and he's also got a loan for the company assets, which is a loan that he signed a personal guarantee for. And he's got some other business debts of about $15,000. So the house that he owns as joint tenants with Rebecca, that automatically would go to Rebecca as the surviving joint owner of the property. I've put a red arrow next to this one because of an issue with the personal guarantee that he signed for the company. The joint bank account works the same as a jointly owned house. The bank accounts automatically go to the surviving joint owner, so they don't get frozen or anything like that. They just continue to operate as normal for the surviving spouse. Unfortunately, there's not much money in there for her. And then the bank accounts in his own name, they essentially get frozen, and in this particular scenario, given that there's really not much to divide, would essentially go to Rebecca. The company assets, I've put a red arrow next to that because we have some issues with the loan. Now, the items that I have there that are starred, they generally don't form part of an estate. Technically, anything that is jointly owned like this would go to the surviving spouse. Company assets generally don't form part of an estate because it's a separate entity. But I've put a red arrow next to the house and also next to the company assets because of the deceased's dealings with the company, and unfortunately signing a personal loan guarantee that meant he was putting up for grabs by a creditor all of his assets. Then the creditor, if they have concerns that they're not going to be paid all of their liability amount, particularly in this circumstance where the assets are only worth $45,000, but the loan owing is $75,000, the creditor immediately knows that even if the assets are sold, they're not getting all of their money back. So because of the document that he signed to secure the loan, the creditor can, and in this particular case of mine, has put a caveat on the house that was owned as joint tenants. Problem with that is when a creditor goes along and just lodges a caveat against a house, they don't seek any permission to do that. They don't tell you that they're going to do that. They just do it. And that also can put a person in breach of their loan obligations. So not only does a caveat get lodged on the title for the property, but then the bank starts knocking on the door saying, hey, you're in breach of your loan agreement now, and we reserve our rights to deal with that breach in whatever way we are able to under your loan agreement with us, which generally means what the bank can do is take control of the house, sell it, pay off all of the debts to them and to the creditor, and leave Rebecca without a roof over her head. So these scenarios essentially came about because of a lack of estate planning. If he had some advice initially in relation to what he should and shouldn't be doing, particularly when it comes to signing things like personal loan guarantees, things could have been a little bit differently, which we'll see a bit later on. So there's quite a few debts in this particular estate that are outstanding as well, which you can see on the screen. I don't need to go through those. Now, superannuation. So we've got rid of the bank account in this particular scenario, but the superannuation, normally I've put this as a red flag as opposed to a green flag, because in this particular scenario, he didn't have a binding death benefit nomination in place. Now, a binding death benefit nomination is not just when you set up your super and you nominate who your beneficiary is going to be, which nowadays you can do on your portal. When you log in, you can say who your beneficiary is, you can change who your beneficiary is. That's not a binding death benefit nomination. All you're doing is nominating a beneficiary. A binding death benefit nomination is a completely different form, and each industry super fund has their own specific form to fill out so that you can have a binding death benefit nomination in place. The difference between having one of these in place and not having it in place: if you don't have it in place, the trustee of the super company can decide where your super goes to. So if there are eligible people to make a claim against your superannuation, so in this case, the eligible people to make a claim against John's super are his surviving spouse and also his 3 children. So each of them need to complete certain documentation to make a claim. The trustee of the super fund will go through and assess everyone's claim. If they want further information, then they'll request it. And then they will decide how the superannuation and death benefits are going to be divided between those 4 people. If he had a binding death benefit nomination in place, whatever form he wanted that to be, the trustee cannot step in and make a decision. It's John's decision exactly where that money goes. He may have wanted to give a large portion of it to his surviving spouse and a small portion to his surviving children, or vice versa. The length of time that it takes in a scenario where there's no estate planning in place, there's no binding death benefit nomination in place, to go through the process of everybody applying and the trustee considering everyone's applications, in this particular scenario of mine, it took 9 months. Now, my client, who's the surviving spouse, was in extremely difficult financial circumstances. She had no money. She had no money to pay for medical treatment. She had no money to pay bills. She ended up being on a disability pension, which pays for bugger all. And if he had have had a binding death benefit nomination in place, it could have been a completely different scenario for her. Rather than it taking 9 months, it may have taken a matter of several weeks. It could have even been 2 or 3 weeks, and she would have had an instant injection of funds into her household to be able to pay for bills. So it's a really big impediment when people are not in fabulous financial circumstances, and then one of them passes away and they're left in this type of scenario. So no estate planning in place versus having some estate planning in place. So I've been through the superannuation binding death benefit nomination on the left-hand side of that slide. So with the surviving spouse and the children being able to make a claim, and it taking a really long time for anything to actually happen and the monies be paid, can cause significant distress to a loved one left behind. Whereas on the other scenario, if they had been to an estates lawyer and got their estate planning in place, we go through binding death benefit nominations and the importance of them, and we always lecture clients a lot about ensuring that they have it done. I even get clients to make sure that they send me a copy of the form once they've actually completed it, or confirmation from the superannuation company, so that I know that it's actually been done. Because I deal a lot with the state administration and I see the mess that needs to be cleaned up and the difficult financial circumstances that someone's left in when it's not in place. I'm a big lecturer on making sure my clients have all of that in place. And particularly when a client like this is dealing with significant injuries and has significant rehabilitation that she needs to undergo, and is in a position where she will never be able to work again, it would have been really helpful for her to have an injection of funds very early on, so that she could immediately pay for all of the private related treatment that she needed. And it can take a matter of several weeks. I've had, it varies depending on the superannuation organisation. Some are better than others. I'm starting to make a list of all the ones that are painful to deal with when it comes to estate administration, so that I know who not to have my super with. Unfortunately, one that I do have it with is one of the painful ones to deal with when you pass away, so I'll be considering that. But I have had some applications where a binding death benefit nomination is in place. It's only taken a couple of weeks to actually get some money to a spouse. Company debts on the left-hand side, where there's no estate planning in place, organisations don't like not getting paid, and they'll do whatever they can to make sure that they are. So when borrowing money, personal guarantees come into play, and obviously caveats can come into play as well. There can also be issues for an accountant if a company is winding up essentially voluntarily, which is the ideal scenario to try and ensure that when someone passes away, the company is not so far in debt that it needs to be essentially bankrupted. If it can be voluntarily wound up, that's a much better option. There's a significant increase in the costs if a company needs to essentially go down the bankrupt path. So it's not ideal. And in an estate like this, where there's not much money to actually deal with anything, the last thing you want is more things to deal with. Company debts on the right-hand side, where there is estate planning in place, one of the things that we go through with clients is we make sure that they have insurance in place to pay debts, particularly when they have a business. So having insurance in place in this particular circumstance, there would have been money to pay out the debt, which would mean that there would be no caveat lodged against my client's house. She wouldn't then be in breach of her mortgage, and life would have been a lot more simple for her, just for some simple insurance being in place. The house on the left-hand side that is owned solely, that house, the loan essentially needs to be paid out. So the property needs to be sold and the loan paid out. So on the right-hand side, if there had have been some estate planning in place, again, one of the things that we do is talk to the clients about having insurance in place. An insurance policy to pay out a mortgage in a variety of different circumstances, whether it's death or there's injury or any of those types of things. It's really important to ensure that there's something in place so that you're not left in devastating financial circumstances if something happens to your spouse. And then on the left-hand side, again, with the house as joint tenants, a creditor who's owed money for company debts in this case has lodged the caveat. It prevents any dealing with the property. She can't do anything. The property can't be transferred over into her name. The property, she can't look at refinancing. She can't do anything with this property at this point in time. The only thing that can be done is for her to basically palm the bank off to me and for me to deal with the bank to try and get them to not be so hasty with their decision making in enforcing their rights under the mortgage relating to her breach, which so far I have managed to keep them at bay, but that's not going to happen for a great deal longer. They've been very patient, but banks' patience wear out. The house as joint tenants, again, if they just have had some insurance in place, then there wouldn't be an issue for her to deal with. All right, so in this particular scenario, if a will had actually been in place for the distribution of this particular estate, not that it makes a great deal of difference because there's really at the end of the day going to be no money to pass to anyone, so the surviving spouse will get whatever is left. But in a case where there is a much greater estate that needs to be distributed, then the deceased is the one that's determining where it goes and who it goes to, which is the ideal scenario. So again, we want to see this face. We don't want to see people frustrated, and we certainly don't want to see the loved ones left behind in the frustrating circumstances that they can be left in. The significance of the financial disruption when estate planning is not done can be really significant. The scenario that I went through today, which is a real life scenario that I have for a couple of clients, it's not necessarily just something that you come across every now and then. It's a pretty regular occurrence. I have in my estate administration practice, probably half of my administration is intestacy, and they are, when I say the most difficult clients to deal with, they're not difficult in that they're horrible clients. They are put in very trying circumstances, and when someone's been involved in a motor vehicle accident and are suffering significant injuries themselves, the one thing that they want to be concentrating on is getting themselves better physically and mentally. And it's a long road when it's, preaching to the choir here with injury lawyers, but you all know what a long road it is for clients when they've been involved in a significant accident to get themselves back on track. And it's not just physical, it's the mental state as well is really difficult. So that's the end of what I was going to go through today. So I'm happy if anyone has any questions.
Hi, it's Margaret from Toll. How are you?
Hi, Margaret. I'm well. How are you?
I'm good. I've just got a question in regards to a funeral account.
Yeah.
Where a testator who's passed away set up a joint bank account with the surviving child that holds like $15,000 just for the cost of the funeral. Can that surviving child then withdraw that money to pay for the funeral, or does the $15,000 forms part of the estate?
$15,000 forms part of the estate.
Okay.
So yeah, so where you see people with joint bank accounts, technically the funeral costs can't come out of that joint bank account. It needs to come out of the deceased's own bank account if they have one in their own name. But if the joint bank account in that scenario is with the child, and the child is happy to essentially have the funeral account come out of that account, then, you know, that's a decision that they can make. It's out of the goodness of their own heart, but it's technically an estate debt.
Okay. But wouldn't the funds be frozen in the deceased person's account?
Not in joint account.
Non-joint account. Okay.
So not for the deceased's own account if it's in their own name. Yes, they are frozen from money coming out of the bank account, but there are certain expenses that take priority, and I'm speaking for Queensland in particular. Funeral and testamentary expenses take priority, so often you can arrange to give the bank a copy of the invoice and get the bank to pay it out of the deceased's own bank account, and they'll do that.
Okay, thank you. I just have one other question, sorry.
Yeah, go for it.
Can an executor who is not a beneficiary to the will be paid to administer an estate in Queensland?
Yes and no. Yes, if the will says they can. And there are very strict guidelines in relation to what a being paid executors commission clause needs to actually entail, and there's specific advice that needs to be given in relation to what the fees might be as well. It needs to be clearly outlined what the executor is being paid for and how those fees are calculated in the will. If it's not in the will, or if it is in the will but the clause is insufficient in terms of the law, then an application needs to be made to the court for the court to approve executors' commission to be paid.
Okay, thank you, Danielle.
No worries, you're welcome.
If there were any other questions, you're welcome to go for it now.
Sorry, Jatara, I wasn't sure how long the presentation was going to go for, needed to go for. So I thought, I think it's meant to be about 40 minutes.
Perfect timing, and it was really interesting. And I mean, personally for me, I went from going from knowing absolutely nothing about this area of law to knowing a decent amount, which I guess, especially this type of law, will inevitably fully affect all of us eventually. So it's really interesting, and I really like the concept. Yeah. If there was no more questions today, I guess I'd first of all like to thank Danielle again for presenting, and thanks everyone for joining. And what I'm going to do as well, I think I mentioned this earlier, but I'm going to send through a follow-up email to everyone, and that's just going to include sort of a link to the presentation, so that you guys can reference the slides later on, as well as a link to the recording once we've finalized editing that as well. And so if people had questions as well, thanks. I can see Pia and Abigail just commenting their thanks just then. And if you guys had any other questions that you realized that you forgot to ask or you thought of later, you're welcome to send me an email, or reply to the email that I'll send you guys. And I'm sure Danielle will be happy to answer them if I send them through.
Yeah, that's fine. The one of the things that I'll add, which I didn't put in the presentation, but just for everyone's information, it's one of the comments that I do receive a lot, not just from injury lawyers, but from lawyers across the board, is that often the comment that I hear is, my client doesn't really have anything, so they don't really need to worry about it. Yes, they absolutely do need to worry about it. one of the things that I always say to people, the minute you start working and the minute you start having superannuation put aside, you need to have a will in place. And you need to have an enduring power of attorney in place. Even when I've administered estates where there hasn't been much in the estate at all. In fact, there's been negative money in the estate, and it's really difficult to do some things without either a will in place, or if there's no will in place, then letters of administration. So one of the things that you do need to cross off from an administration point of view is tax. Now, the ATO changed their tax laws or their policy towards the end of last year. They don't provide any information in relation to a deceased person's tax situation or history if there's no will or there's no grant of letters of administration or grant of probate. Now, it's much cheaper for someone to potentially get a will in place than it is to get a grant of letters of administration. So it's a lot better to spend the money early up than have it the expense later on, and particularly for someone that really doesn't have anything much to give. They might only have a few $100s in their bank account. If they don't have a will in place, then they're leaving their executors in a really difficult scenario of going to the expense of applying for a grant and potentially paying for that out of their own pocket just to cover their own bums and cross off the tax component.
Great. Okay, and any more questions before I finalize this one now? I think that might cover it. Okay, what I might do, I might drop my email address as well in the chat box now. So that's my direct email address. It's a bit of a long one, so you might want to copy and paste it. It's a bit of a mouthful, but that's my email if you guys had any questions, and I will be forwarding everyone some more information later. So thank you very much.
Excellent. Thanks, Jatara. Thank you, everyone.
See you later.
Bye.